You know that feeling when you're scrolling through your phone and suddenly you realize that every single move you make, every single thing you search, every single person you talk to could be recorded and stored somewhere? Well, that's not just a feeling, that's reality. What happens to this digital footprint? Is it protected by the Fourth Amendment? The answers to these questions all relate to something called the third-party doctrine. And Katz. No, not that kind of Katz. This kind of Katz.
I think the name of the doctrine makes it sound arcane. People start to glaze over. They think, oh, it's technical, but it is so important.
So the third-party doctrine is the principle that a person doesn't have a reasonable expectation of privacy and information turned over to third parties, to other people, for example, your bank or the phone company.
And whether you have that reasonable expectation of privacy is important because according to current Fourth Amendment doctrine, if you don't have a reasonable expectation of privacy, then if the government gets that information, it's not considered a search. Government does not have to provide a warrant, no probable cause, no particularized suspicion.
I think the third-party doctrine is largely outdated. It's a concept that I think was not sufficiently protective of privacy at the time, and certainly is not sufficiently protective of privacy now in the digital age when so many of our very sensitive and intimate records are held by third parties just by nature.
Those are outdated concepts, all right?
This idea of third-party disclosure is not a new idea.
This is not a new issue. This is not a new technology.
I don't think it becomes outdated to apply that traditional historical textual principle of the Fourth Amendment. The question is just how to apply it to the internet.
To understand why certain information turned over to third parties is not protected by the Fourth Amendment's warrant requirement, we need to go back to a Supreme Court case from the 60s called Katz versus the United States.
Before 1967, when the Supreme Court decided Katz versus United States, there was real uncertainty about what the Fourth Amendment protects. The challenge was that the government was using new technologies to invade privacy in a way that didn't involve physical intrusion.
There's a tap on that phone booth, right?
Yeah, we got it.
What do you do if there's a microphone placed outside of a space without physically intruding into the private space?
And what happened in Katz was the government was listening to the phone calls of the target of the investigation. There was no property right there because the target did not own the public phone booth. He didn't have any traditional Fourth Amendment objection that the government had intruded on his private property.
Oh, wait a sec. What do you mean? The government can just wiretap my phone calls? How did that happen?
In the 1930s, in a case called Olmsted, the Supreme Court said, it's perfectly fine for the government to wiretap you without a warrant. Cable lines go all over the place, they go outside your home, and that was what the law did for about 30 years. By the mid-60s, phones were a lot more common, and we'd had a pretty good track record of how poorly that idea worked. The Supreme Court, I think, looked at this and said, this just clearly can't be how things are. Clearly, the Fourth Amendment would not want this type of invasions of people's private conversations to occur.
Couldn't this maybe be construed as illegal, invasion of privacy?
The Katz case says, no, you don't need physical intrusion for there to be a search, that the phone booth is protected just like a home would be protected, and it doesn't make a difference that the microphone was on the outside of the phone booth instead of coming into the phone booth. Why? Well, because it's a space where you deserve a reasonable expectation of privacy.
The Supreme Court in Katz had a two-pronged test. One, did the target have a subjective expectation of privacy? And two, is that subjective expectation something that society regards as objectively reasonable?
Comedy is subjective, Murray.
And so the court said, no, you can't wiretap people's phone calls without a warrant because that intrudes on a right to privacy that is both subjective and objectively reasonable.
I've also watched enough TV to know that you need a warrant.
You would think, and at the time, of course, it seemed to be, that by using that reasonableness language, that protection for privacy was enhanced. But what you saw over time was that prong about society, recognizing the expectation as reasonable, that overtook things. And so There were a number of cases in which perhaps protection for privacy would be withheld because it was a case in which a judge thought society was not prepared to recognize that expectation as reasonable.
That's unreasonable.
It's unreasonable, but I have here...
No, it's unreasonable.
Yes, ma'am, it is, absolutely.
So, it's unreasonable.
A mistake the Supreme Court made, I think, is in talking about reasonable expectation of privacy and not clarifying that it's just a term of art to try to get to what is your paper or your effect in a technological world.
The court's decision may have been handed down over 50 years ago, but the issues it raises are just as relevant today. Except we're no longer just dealing with microphones.
Now you wonder, if that's the origin, how do we get to today where it seems to be applied to all of us? And what happened was, in the 1970s, there were two cases. One is Smith, one is Miller.
These involve the government collecting a set of bank records and a pen register, which is basically not the content of your phone call, but who the calls are from, who the calls are to, when the calls occur, and how long they go on. These types of records, the Supreme Court looked at and said, well, is there a reasonable expectation of privacy? And they held, because of the fact that these records were held by a third party, banks and by phone companies, they said no.
The Supreme Court in Smith and Miller built on the decision in Katz, but changed the language to expand the scope of what constitutes conveying information to the public.
Now you think, how is that possible? Well, what happened is this doctrine grew up in what's called the secret agent cases.
Charming, sophisticated secret agent.
So you think of Tony Soprano in his basement sharing information with somebody who turns into a criminal informant. In that situation, it's very easy to say, no, Tony Soprano, he doesn't reasonably expect this guy to keep everything private. After all, they're criminals. Common law would look at the arrangement between those two and say they have an illegal contract. That's just not true when you fast forward to the 70s and you have the Smith and Miller cases. And you have me and you, ordinary people, we're not mafia, and we're sharing information with our telephone company or our bank. And yet the Supreme Court just took that doctrine from the criminal context over into that context and said, nope, no reasonable expectation of privacy, government can obtain it without a warrant.
The text of the Fourth Amendment provides rights in your house, your person, your papers, and your effects. If you want to make a contract with someone in which you try to have a deal with their person, their effects, and their papers, contract law can recognize that, but I don't think the Fourth Amendment recognizes it. And a challenge with making the test hinge on what is a legal or illegal act is the government is investigating the case, trying to discover illegal acts. They don't know ahead of time whether it's a legal or an illegal contract under some sort of common law concept.
Although the third-party doctrine and reasonable expectation of privacy test have a complex and debated history, the bottom line is that your data shared with third parties is not protected by the same standard of the Fourth Amendment's warrant requirement. But is this true for all your data?
The Supreme Court has not really addressed digital spaces like, for example, cloud drives in a clear way. I think it's pretty clear that the music of the cases, so to speak, indicate that those areas would probably be protected.
Courts, I think, have mostly been figuring this out pretty sensibly. They've said email is like mail, and addressing information on an email is like addressing information on a letter. And so they've drawn a line between content and non-content information, between content and metadata.
Metadata?
She doesn't know what metadata is.
Metadata is data about data. So with respect to a phone call, it would be the phone number that you dialed, the time that you made the call. It could be with respect to a cell phone service provider, where you were when you were making that call. So it's about the conversation, but not the conversation itself.
The Department of Justice has long drawn a distinction between metadata and content. Metadata has been subject under the third-party doctrine framework to subpoena-type standards, lesser standards. This came up a lot with the Edward Snowden disclosures of various national security surveillance programs and what exactly was required to get certain information from third-party providers.
I think that there's a lot of limits to that approach. Obviously, metadata can be extremely sensitive and revealing, whether you want to quit a job or hiring an attorney for something you worry about, whether you got an abortion, whether you bought a gun. Not the communications of the calls at all, just the metadata. So it's very sensitive, but under the traditional model of those 20th century cases, content versus non-content has been a pretty clear drawing line.
It's the traditional approach to postal mail, going back to the 1877 Ex parte Jackson case, which said that when you send something through the mail, you have Fourth Amendment rights if it's sealed, if it's a sealed letter, but you don't have Fourth Amendment rights in the outward content of your letter or your package, and you don't have Fourth Amendment rights in anything you send in a way intended to be exposed to the post office, like a magazine, for example, or a newspaper.
So until very recently, the traditional line by the Supreme Court has been between your data and your metadata, although how it affects digital spaces has not been explicitly ruled upon.
But then came the Carpenter case a few years ago, in which the Supreme Court held that subpoenas directed to the phone company to figure out which cell towers a person's phone hit when the person was walking down the street or driving required a warrant.
This case involved a man named Timothy Carpenter, who was convicted of several robberies based on location data obtained from a cell phone provider without a warrant. Carpenter argued the government's acquisition of his location data was a violation of his Fourth Amendment rights, which protect against unreasonable searches and seizures.
What the Supreme Court majority in a 5-4 decision written by the Chief Justice said,
because this is so invasive and because that type of information generated to a third party, your cell phone, which pretty much everyone has to use and which only function by sending location data to cell phone companies, the third party doctrine simply can't exist in that case.
And that was sort of a revolution in Fourth Amendment law. I think actually Justice Alito's dissent called it revolutionary because under the traditional third party doctrine, those were just business records of the phone company that captured certain information that users of cell phones transmitted to the phone company. So on a very straightforward application of the third party doctrine, really that should not have required a warrant.
Every cell phone, just about, has a microphone, camera, and a means to transmit data.
I think it's easy to read too much into Carpenter. It's a pretty narrow decision dealing with a new technology, historical cell site location records. And the problem the court had is that under the old rules of applying the Fourth Amendment, suddenly the government was basically going to have a windfall because of how technological change had shifted what records were available to the government. And the court did what I've called equilibrium adjustment. And the idea is if technology is really dramatically transformed government power, the Supreme Court has a tendency to try to shift the rules to try to restore the prior balance of protection. The court said, wow, we might be in a world of Big Brother if the government can access these records and know everyone's location. And so they said, well, this information then the government can't get without a warrant, basically to avoid that dystopian world of the government just having too much power.
This is too much power for one person.
So Carpenter may or may not be a revolution in the Fourth Amendment law. It sounds like we're currently in a gray area in terms of what data is protected online and what is not.
As a law professor who writes and teaches in the area of Fourth Amendment law, I would love for the Supreme Court to hear more Fourth Amendment cases. It would be good for business. The court acts slowly. It tends to wait for the technology to develop. And I think that makes a lot of sense.
I think the idea when you have these ambiguities really do always tend to come at the harm of privacy rights and to the benefit of law enforcement when they want to be more invasive. As long as that's ambiguity there and is going through the courts, typically law enforcement can exploit it. And the courts typically give law enforcement a very big bit of leeway to, if they in good faith think that they're following the law or relying on good law, then it was okay at the time. So as long as those ambiguities are there, until there was some sort of clear sign from a court of jurisdiction that says you can't do this, law enforcement does kind of have free reign.
I don't know if the ambiguity favors law enforcement or not. The unclear state of the third-party doctrine, I think, probably encourages law enforcement to get a warrant whenever they can. But when they can't get a warrant, when they don't feel like they have probable cause, I think certain investigative steps might not be taken. If you're worried that, X investigative step could result in the suppression of evidence because the doctrine's unclear, you may be advised by the Assistant United States Attorney on the case to hold off on that and seek to develop the evidence other ways that are clearly lawful.
With all the ambiguities in the air surrounding what is and what isn't covered by the third-party doctrine, is it time for Congress to weigh in? And in the meantime, is there anything people can do to protect their own data?
There's a lot of great steps individuals can take to better protect their individual privacy. There are tools like VPNs to protect your web browsing activity. Communications that are end-to-end encrypted are much, much safer from being grabbed than those that are actually held in free text by the third parties that help you transit them. And in general, looking at companies, apps, services that will just collect less data in the first place is important. Really, the onus should be on the government here to protect them. It shouldn't be an individual's responsibilities, given how much data we put out in the digital sphere all the time, to protect every little bit of information, especially when so much of it is just beyond your controls.
It will be hard to know when it is, but I do think there will be periods when Congress really needs to intervene and establish laws that govern privacy in this area, that supplement the Fourth Amendment.
I suggest you take your case to Congress.
I think it would be helpful if Congress got more granular on what requires a warrant, what doesn't, what are the privacy interests involved, and I suspect the Supreme Court would give some degree of deference to Congress's judgment on that.
It's just hugely important for Congress to be playing an active role. I think what tends to happen is the Congress can step out ahead of it, regulate before you have cases or controversies in light of privacy concerns.
The Supreme Court!
The courts can then come in later. The courts are always going to be lagging, 20 or 30 years behind the technology, and they can sort of establish the timeless principles of how the law applies once the technology is more fixed.
So we have seen some states attempting to tackle this issue, perhaps by even invalidating the third-party doctrine as applied to their states entirely. And whereas I think this is a positive direction for things to go, it can help only so much. So I think, the remedy for this has got to be judicial. And again, I think what you want to do is you want to correct the court where it went wrong, which is back at the time of Smith and Miller.
Something about another course correction.
So what happens next? What should we do with the third-party doctrine, with so many differing views and angles on the topic? Many are left wondering how privacy rights will evolve as technology continues to develop at a quicker pace than legislation can address.
The third-party doctrine of the Fourth Amendment is going to be a critical component of the balance between the effectiveness of law enforcement and Americans' personal privacy. As the internet develops, as more and more information is digital, as people's lives are wrapped up in applications on their phone or their computer that interact with companies, there are going to be real questions about what the government needs to do to access that information while it's investigating crime.
So my solution to this is to recognize the original context in which this doctrine developed, limit the scope of the doctrine to only that context, because there is not a justification, certainly not in common law, certainly not one that respects our rights to property and contract and liberty, that would allow the extension of it into all these other areas.
I think individuals, because of just how intense ad networks are these days, assume that companies get a lot of data about them. But I think that there is some natural squeamishness about the idea that the government can come in and grab that and use it or store it and stockpile it. I think a lot of people are unhappy about that, but see that they don't have a lot of choice about it until we enact better data privacy laws.
It's striking that balance, I think, which is really important, and that our goal should be to retain when we apply all of these rules to the internet. What maintains the balance and what doesn't shift government power dramatically? We wouldn't want to live in a world where the government basically had no ability to investigate cases because of these technological shifts, or had too much power in light of these technological shifts.
As technology continues to progress and more of our lives are shared with third parties, the question of how this doctrine will apply to your life will become ever more important, and courts will have to decide how this applies moving forward.
I'm not a cat.